Yeah, I guess we're gonna go live. I do
Okay,
have,
great.
hold on one second here. Very nice.
Streaming live. It says it's gonna
Yeah.
notice here. I look green.
Very nice.
There we go. Streaming live. It
Can you
says
hear that?
it's gonna. Yes. Although I'm getting a little bit of an echo now. Oh, not anymore. I look green.
Very nice.
There we go. Streaming live. It
Can you
says
hear that?
it's gonna. Yes. Although I'm getting a little bit of an echo now. Big echo. Oh, not anymore.
Interesting.
I look green.
Very nice.
There we go. Streaming live. It
Can you
says
hear that?
And an
yes.
award-winning
Although I'm
documentary.
getting a little bit of an echo now.
In Set for Sentencing, I'm going across
Big echo.
and
Oh, not
outside the
anymore.
box
Interesting.
to help
I look green.
lawyer and
There we go.
client
Streaming live. It
expand
says
their perspective and build
yes.
on winning
Although I'm
documentary.
getting a little
Get
bit of an echo
real
now.
results Set for Sentencing, I'm going across
Big echo.
Big echo.
Not
the box
Interesting.
to help
I look green.
and
There we go.
client
Streaming live. It
Can you hear
says
that?
and
build on
yes.
winning Although I'm getting a little bit of an echo now.
Set for Sentencing,
Like on a weird loop.
across
Yes.
ready
Oh, well.
for
Big echo.
all of the box get set to help
Let's get set for
Streaming live.
sentencing. Sentencing.
Okay.
All right.
Yeah.
Wow. Oh. That's so weird. Yeah, that was okay. Can you hear me okay?
Yes.
All right. Well, I think we're live, and nobody ever said this was going to be without some technical glitches, but here we are. We don't do this very often, but we are live streaming to our Set for Sentencing YouTube channel. This is the Hunter Biden edition. As everybody in the world knows, he just got convicted yesterday of some gun-related charges, and there are so many talking heads out there pontificating about what the conviction means, what the sentence might be, and on and on and on. And this is what we do every week or every other week on Set for Sentencing, and I do it with my good friend and learned colleague Mark Allenbaugh from sentencingstats.com. And we decided we are the definitive talking heads, by golly.
Yes.
And we needed to just get on here and start talking about this case and hopefully set the record straight, because there's a lot of misinformation flying around. But there's basically, I think, 5 things we're going to do today just to set it up, and then I'm going to throw it to you, Mark Allenbaugh, to kick it off. But we're going to talk about the offenses of conviction. What are the sentencing statistics and the possible sentencing that Hunter Biden might face now that he has been found guilty of these 3 charges. We're going to talk about what are his mitigation arguments. What is this narrative he can and hopefully will tell at sentencing to mitigate the fact that he's been convicted of these offenses? And we're going to talk about the concept of acceptance of responsibility, because when someone goes to trial, they don't always get credit for accepting responsibility. And we're going to talk about the fact that Hunter has another trial pending, I think in September. It's a tax case. How will this case potentially impact that case? And lastly, this thing that has been on my mind that I really want to talk about, because I think it's very important to discuss in this context, and it is this concept of the term that we have been hearing over and over and over again, mostly from the right, from the Trump camp, from the Trump supporters, this idea of lawfare. And we just keep hearing this over and over. It's this new word, this darling in the lexicon. Like I said, mostly the right, and it's regards to Trump prosecutions and the prosecutions of all the people in his inner circle, the Bannons, the Giulianis, the Mark Meadows, the Roger Stones, the Paul Manafort. I could probably go on and on for a long time. But I really want to talk about this idea of lawfare. Is this a real thing? What does it mean? And does it apply to Hunter Biden's case? So these are the things we're going to tackle. I have no idea how long it's going to take. I'm just glad to be here, and I'm glad to have you here, Mark Allenbaugh. So let us kick this off. For anybody who doesn't know the specifics, What was Hunter Biden? Let's start with what's he convicted of? What are the
Okay.
statutes of conviction?
So he was convicted by of three separate statutes, all gun-related federal charges yesterday. One was making a false statement in the purchase of a firearm, which is 18 USC 922A6. Also, another related charge for making a false statement related to information required to be kept by a federal firearms licensed dealer. In other words, lying to the dealer. And that's 924A1. And perhaps the most controversial of the charges that he was convicted of was 18 USC 922G3, which makes it illegal for a prohibited person to possess a firearm. And in particular, what the subsection of the statute applies to are those who are drug addicts. And that is a statute that's rarely prosecuted at the federal level. And
sorry, but it's not really necessarily just an addict, it's a user or an addict,
user, right,
which is a pretty broad.
Yes.
I mean, that's probably more than half the country.
And from what I understand in closing argument, that's what Abby Lowell, his attorney, was trying to convey to the jury, that he really wasn't an addict at the time that he purchased the firearm. He may have been before, he may have been at some time after, but he wasn't at that time.
And I thought maybe it was not only that he wasn't an addict, but that in his own mind. I mean, who says you're an addict, and how, at what point do you come to terms? At what point do you come to terms with your own addiction? So if you fill out a form that says, no, I'm not an addict, and you don't think you're an addict, I mean, you are smoking crack at the time, so that's a problem. But let's start here because I want to talk about, I think that my next question is, how commonplace are these particular charges? And I will tell you, I have a lot of experience in the federal system. I've been practicing in the federal system 12 years as a federal defender, 20 years in the federal system at least. And I've seen a lot of false statements in purchase of a firearm. Nice. And I've seen a lot of unlawful possession of firearm cases, especially here in Arizona. We saw those all the time, but I never saw them in the context of drug user or addict.
Yeah.
What I saw them in false statement forms, where you fill out a form, it's the lie is usually concerning what we call straw purchaser cases. In other words, there's a box on the form that says, is this gun for you? And if you say, yeah, sure, this gun's for me, but really you're buying it for your felon boyfriend, or you're shipping them down to Mexico, like operation, whatever you call it, to sell them to the cartel, whatever. Straw purchase. Right. Those are the ones that I saw, and I saw them a lot, and they were common. Never, ever, except for never saw the false statements for user and addict. Now, the possession count, in other words, you're an unlawful possessor. Forget the form, forget the lie. You're just not allowed to have this gun. We saw those all the time, but they were almost exclusively, I would say, 99.999% is what we call felon in possession.
Correct.
You're not allowed to have a gun because you're a convicted felon. Those are the guys that would get prosecuted.
Correct.
I can recall one case in my whole time where there was a charge for 922G3 prohibited because of user and addict. And, you do the research on that. You don't have to look very far to see that there are serious constitutional questions about that count. And now there are constitutional questions about the other counts too. So I just want to know, that's my experience. That's anecdotal, but you're the stats guy. What can you tell me about how common these specific charges are in Delaware and in the country?
Okay, well, let's start within the country. So since 2010, I'm just kind of arbitrarily going back to 2010, there have been just over 1 million defendants or individuals sentenced under the guidelines during that period of time. About 95,000, just a little bit over 95,000, were sentenced under what's called 2K 2.1. And that's the primary firearms sentencing guideline, where you see, for example, you are felon in possession. If you're charged with felon in possession, you're going to be sentenced under 2K 2.1. So that's the primary guideline. Out of those 90, so it's already kind of a small universe, 95,000 out of 1 million. okay, since 2010. So we're already talking about kind of a small universe. But within that universe of 95,000 individuals, only 2,951 had at least one count of conviction for 922G3. And what that means is around 3%. 3% of those that of the firearms offenders were charged with 922G3. If you're looking at overall, you're looking at well less than 1%, less than half of 1%. So it's very rare. This is a very rare charge nationwide, and again, only about 3,000 over the last 14 fiscal years. Okay, and at any given year, there's usually between 60 and 70,000 individuals sentenced. So again, very, very rare. But in the District of Delaware, where Biden was sentenced, unheard of since 2010. Now, there have been 2 or 3 other individuals in that period of time that were charged with 922G3, but it was ultimately dismissed by the government pursuant to a plea agreement. Nobody has been convicted of a 922G3 charge in the District of Delaware, save for Biden, since about 2009, 2008, as I recall. So it's basically he's
Okay, wait, well, let's just
okay.
accentuate that.
Yes.
Since 2008, in the District of Delaware,
Yeah.
there have been 0 convictions under 922G3 until yesterday and Hunter
Correct.
Biden, or Monday
That's
and
correct.
Hunter Biden.
Yes.
Okay.
Yes.
I just want to make sure we put a fine point on that.
Yeah.
And by the way, you know, I'm not going to talk about tequila too much, but I do wish this was section G4 instead of G3, because G4 happens to be one of my favorite brands of tequila. But that's all I'm going to say about tequila today. That's all I'm going to say.
Okay, but let me add something else too. That, you know, the 922A6 charge, that also is kind of rare. That nationwide, there was only 2,722 during the same period of time. And the 924A1.
Are we talking about in Delaware? You said nationwide.
Nationwide.
Nationwide, there's how many?
Only 2,722
since when?
2010.
That's surprising. Out of the million federal prosecutions, that only a couple thousand, and that's for any false statement in purchase of a firearm,
well,
or that's
that's
specific
for
to the drug?
Anybody charged and convicted of 922A6. So the reason why
But that could be any false statement. Doesn't
that could
have
be
to
any
be
false
drugs.
statement.
It
Yes,
could be
that
the
could be
straw
any false
purchase and
statement.
everything else.
Correct.
Is there any way to tell how many of those 2,000 false statements are the drug thing and not the straw purchase thing? Or that would be just a labor intensive looking at 2,000
No, it's not
cases.
very labor intensive, but it will cost me, you know, another Red Bull that I probably don't have time right now. But I could find that out, and obviously it's going to be a subset of that. And so
that's what Mark Allenbaugh does, by the way. He answers those esoteric questions that lawyers,
esoterica,
that curious lawyers have, and he has access to all the data. So maybe someone will hire you to do that analysis. But anyway, hopefully you get paid more than Red Bill.
Just to go back to 2K2.1. So as I was saying, you know, the majority of these cases are federal felon in possession of a firearm, and that's 922G1. And out of those 95,000, 66,000 had a 922G1 conviction. So that's the bulk of them. That, you know, by far and away, it is felon in possession. So, but these other charges, but I mean,
and by the way, look at this. I'm sorry to keep interrupting, but I want people to have a practical view of how the system works. And this may be leading into the lawfare thing we do later, but the felon in possession charges are obviously, like you said, 66,000 is far and away the more ubiquitous, right? But there's a reason for that, because that's an easy one to figure out. In other words, you have law enforcement contact, you get arrested, they find a gun on you, they run your criminal history, and they say, oh, you don't get to have this gun, and all of a sudden you've got a felon in possession charge. So usually there's something else putting you on the radar of law enforcement that exposes the fact that you're not allowed to have this gun. But when you're talking about going into a gun shop, a federally licensed firearm dealer, which by the way, Hunter wouldn't have had this problem if he would have just bought his gun at a gun show, because they don't have, there's a loophole and they don't have to fill out the same forms, I don't think,
Right.
but that's another conversation. But the point is, unless there's something that puts you on the government's radar, how does the gun dealer even know you're smoking crack at that moment in
Right.
time? Or
Right.
how do they know this gun's not for you? You have to be on the radar. And in fact, the one user in possession thing I had was a case where the government was right after 9/11 and the government was targeting this person for investigation because of his political affiliations. And they found out this, that, and the other, and he got that charge. But he never would have been looking at that charge had he not been on the radar for some other stuff. And I think that's bears noting. So anyway, go ahead. Sorry, I don't want to take us that far
all I
off
was
track.
going to say, basically, all three of his offenses of conviction are relatively rare. I mean, we said the G3 less than 3,000, the 922A6 2,700 nationwide since 2010, and the 924A1A. I'm going by subsection, just over 2,000.
Yeah.
So all of
Rare.
those are pretty rare. And as a matter of fact, looking at Delaware, like I said before, since 2000, there have been 0 convictions under G3, only 16 for A6, and just 3 for A1A. So
Okay.
Hunter Biden made the combination of his charges and conviction may very well be unique in Delaware, and I'd have to do a little bit more research. But I'm sure there have been others like that in nationwide, but they're just a handful. So it's the combination of the charges too that make this a really unique case.
And that begs the question: how did Hunter get so lucky as to be one of the few, the proud, the few, the convicted of these?
Well,
counts?
we know why, as we discussed from our last podcast on this, was the plea deal that the parties had put together, the government and Biden's attorneys, fell apart when the judge started questioning that.
Right.
So
they were going to give him diversion on these gun counts, and he was going to plead to some tax stuff.
Right. I think misdemeanor tax, as I recall, too.
Yeah. So now he's got 3 felonies. We got to talk about sentencing. One aspect of sentencing is sentencing parity, treating like offenders alike. And the first place we usually go to are the statistics. What are the average, mean, median sentences for people, for that small subset of people get convicted on for these counts? So let's start there. What are the stats? What are the stats telling us?
Well, the first thing we need to do is figure out what the guidelines are going to say. So we go to 2K 2.1, we look at the guidelines there. And for his A6 offense, that's going to be the driver. He's going to be at a base offense level of 14. But to my knowledge, none of the other sentencing enhancements, or what we call specific offense characteristics, apply to him. So he's just at a 14. Now, remember, he went to trial, so he doesn't get, at least on the face, he doesn't get acceptance, but I want to return to that in a second. But assuming that he's just at a 14, he doesn't get any other enhancements, doesn't get any other.
For people who don't know, if you get acceptance, which usually happens if you plead guilty, not go to trial, you get either essentially automatically 2 or 3 levels off. If it's less, if you come out less than a level 16 on the guidelines, you get 2 levels off.
Correct.
And over 16 is 3. So if he gets acceptance, or had he pled guilty, he almost certainly would be dropped 2 levels to a 12, is what you're saying.
That's correct.
And these levels, for people who don't know the guidelines, there's a whole chart. These have nothing to do with time in prison yet. They're not 2 years or 12 years. They're just the numbers on a grid that we're getting to get to what the guidelines suggest the sentence should be. So keep going. Sorry.
Okay, no problem. So I'm on something right now. It's kind of high level and full of kinks. It's called the Judiciary Sentencing Information Network or platform. And sometimes if you just want a really high level feel for where sentences are kind of coming down, you can look at this. But it is and very often it can be misleading. At any rate, with all those caveats, let's just take a look at it real quick. The reason why I'm bringing this up is because many districts now are having their probation officers include the output from what we call JSON into the pre-sentence investigation report. So looking at 14, so an offense level 14, and he's going to be in criminal history category 1. He doesn't have any criminal history. That's a sentencing range of 15 to 21 months. And as you already alluded to, Doug, the sentencing guidelines are merely advisory. So a judge doesn't have to give 15 or 21 or anywhere in between, can give above or below. But nationwide, over the last 5 fiscal years, there were 52 defendants that matched this, what I call sentencing profile. They're sentenced under 2K 2.1, total offense level 14, criminal history category 1. And of those 52 defendants, the average sentence was 14 months and the median was 15 months. The median is the halfway point, and when you line up the data from lowest to highest. 4 of these defendants, it looks like, received a non-custodial sentence. So that's, so the point simply is here, just looking at this data, the chances of Hunter getting a non-custodial sentence are rather low. But what Jason doesn't tell you is what we call the dispersion, how close or far away do all these sentences fall from the average or the median and things of that nature.
I got a question for you.
Sure.
Did you factor in 0-point offender, or does that not apply for this count of conviction?
Well, unfortunately, so you're referring to the new downward adjustment for the 0-point offender at 4C 1.1. And unfortunately, it's not going to apply to Hunter. I'm pretty sure that he has 0 criminal history points, but because there's a gun involved, this is the 7th. There are 10 criteria you must meet in order to be eligible for the 2-level downward adjustment for 0-point offender. One of which, of course, is that you have to have 0 criminal history points, which he does. But one of the other criteria, it's the 7th one, gun can't be involved.
Okay.
So pretty much any firearms case is precluded from getting the 4C 1.1. So
okay.
yeah. So yeah. So basically, if he's I looked at the last 10 fiscal years for everybody sentenced under 2K 2.1, total offense level 14, et cetera, removed all the mandatory minimums, removed all the 5Ks, which are the cooperation sentences. There were still 186 cases, but unfortunately for Hunter, the data is about the same. The average sentence was 12.5 months and the median was 15 months. 29 individuals received a non-custodial sentence, or about 15%. So maybe that's around 1 in 7, 1 in 8 defendants received a non-custodial sentence. So that's that is at least promising. Some of these defendants, I mean, there's a substantial pool that counsel could look to see, who else received a non-custodial sentence and why. And they're basically exactly the same as far as the guidelines are concerned as Hunter is. But this brings up even though Hunter is not eligible for the 0-point offender, of course, it could be argued for a downward variance because this wasn't a crime of violence. It really wasn't a serious offense, at least serious on the level of a crime of violence. And he's a first-time offender. So but for the gun, he meets the criteria. So there was an argument for downward variance. But with all that said, I think there's a strong argument that he could still be eligible for acceptance of responsibility, depending on how he allocutes. Now, problem for him is he's going to be appealing. We already know that he wants to appeal this conviction.
Yeah.
So whether he's going to allocute or not, which means speak at sentencing, and either fall on his sword or not, that presents a problem for him if he's going to appeal. If he were to accept responsibility, during allocution, I think there is a strong argument here. It's an unusual argument because it's unusual facts that he should still be considered for an actual 2-level downward adjustment for acceptance of responsibility, because he did try to accept responsibility. He was going to enter into this diversion program that we spoke about. But the judge essentially forced him to go to trial. And so I think that
if you remember, even with this back and forth, he was still going to say, okay, I still want to do this. I still want to do this. And then my recollection is it came down to the government would not avow that they weren't going to prosecute him for any other charges.
That's right.
Any good defense lawyer at that point would say, well, then what's the plea? What's the value of the plea? There's no certainty of the plea. He wanted to plead guilty. He was standing before the judge. He was admitting responsibility for everything. And arguably, it was the government and the lawyers and the judge that tanked this plea. That's
exactly.
If it wasn't for that, he'd already have these cases behind him. He'd be on.
Correct.
So yeah, I like that argument. And I also like the argument that, there's legal challenges to these statutes of conviction. And I'm not necessarily denying responsibility or denying the facts or denying that I had substance abuse issues or denying that I bought the gun. I'm simply, preserving these issues for appeal. And I have to. Well,
this is the Daniels case, which is out of the Fifth Circuit, which Hunter or Abby Lowell and his attorneys briefed to the district court judge. Unfortunately, didn't go anywhere. But the argument is the Fifth Circuit recently found that 922G3, which is one of Hunter's offenses of conviction, was unconstitutional. It violated the Second Amendment, the right to bear arms. And what they held, the Fifth Circuit said in that case, the Daniels case, is for those who possess and use marijuana. So it was an as-applied challenge. Those that used marijuana, it was unconstitutional. That case is now
a little different.
Crack is a little different. But up until recently, marijuana was a Schedule I drug, just like cocaine and crack. So I think there might be an argument here. And as far as I recall, Daniels is still pending. There's a petition for cert pending with the Supreme Court still. And I know there's another case, Rahimi, which has to do with another gun provision that actually the court did hear, and we're just awaiting any day now to hear what the Supreme Court comes back with on that.
And I think just generally the Second Amendment is having its day. So people are winning a lot of gun cases on a lot of issues. So that could be an interesting thing.
But unfortunately for Hunter, all that does is get rid of one of the charges. So
okay. Well, so acceptance will be an issue, and if the judge gives him some bit of acceptance, then his guidelines could be lowered. But here's the thing: the guidelines, as we've said more than once today, are advisory. There's no mandatory. They give the judge advice about what the sentence should be, and the judge is free to disregard that advice. And the operating sentencing statute that the judge must consider is 18 U.S.C. section 3553. They must look to the nature and circumstances of the offense, the history and character of the person, need to deter, need for treatment, all these factors the judge must consider. And judges can, and as you will tell us frequently do, disregard the advice of the guidelines, because the guidelines are, we've called them the drunken uncle at Thanksgiving. Like, you're never going to take advice from the drunken uncle at the Thanksgiving table. And the guidelines have really become deeply unreliable as giving the judge good guidance on what a sentence should be. So speak generally, how often are judges disregarding the advice of guidelines in any case and going below the guideline range?
Well, that's a good question. It really depends on the offense of conviction or the offense type. Violent offenses, judges tend not to go below the guidelines. For violent offenses, they tend to follow them. But for fraud offenses, white collar or economic offenses, judges are going increasingly below the guidelines. As a matter of fact, as the fraud increases, the judges go below the guidelines not only more frequently, but to a greater degree. So low frauds, they might go below the guidelines a third of the time and might give you a third off the bottom of the guidelines.
And
But when
you're
you go
not
up to,
talking about the nature of the fraud. You're talking about the dollar amount of the fraud.
yeah, I'm talking about the dollar amount of the fraud.
Yeah.
Yes.
That's
Yes.
a little different
Yeah.
calculation, but okay.
Yeah. But yeah, if it's a large dollar amount fraud, in those cases, the judges are going below the guidelines 70-80% of the time, and they're giving well over half off the guideline range because the guidelines just skyrocket. It's almost like they exponentially increase for those. Child pornography cases is another one that judges frequently go below the guidelines, mainly because they're ratcheted up so high, and every specific offense characteristic applies to the defendant. So it doesn't really, they're not well calibrated or fine-tuned to individual defendants. It's basically everybody gets the stat max.
By the way, I don't know if you want to take a trip down memory lane with me right now, but the first Set for Sentencing episode we ever did was a live like this, and it was during or right on the heels of the Ketanji Brown Jackson confirmation hearings, where she was taken to task when, as a district judge, she would routinely depart in what? Child pornography cases.
Yes.
And that was like the big thing that they did, and we talked about that. So that was like 2-3 years ago, because we're on like close to 100 episodes right now. But I think that was the very first thing we ever did on this was about that. So there you go. There's your trip down memory lane.
Well, thank you. I remember that. I do remember that now.
So he's got a great lawyer. He doesn't need our advice, but this is what we do. This is when we talk about crafting sentencing arguments. So the stats, the guidelines are a piece of it, but we would argue a small piece that you really have to tell a powerful sentencing mitigation story to help the judge understand why those guidelines should not be followed. And I won't spend a ton of time on this, but I think there's a ton of things that the lawyer can, should, and I'm sure will do when it comes time to talk to the judge about what a fair sentence will be. I call them the 3 R's of sentencing storytelling, and these are revelation stories, relativity stories, and redemption stories. And the revelation stories are, how did I get to this moment in time? These reveal often deeper, usually hidden truths, but Hunter's life is literally an open book. But just to help the judge give context, not to excuse, but to say, yeah, I know, I screwed up. I was deeply addicted. And by the way, because of this whole lifetime of trauma that I've been dealing with, I fell into a spiral of addiction. I'm deeply ashamed of it. And that's at the heart and soul of this case. He wouldn't be charged if he didn't have the addiction, period. There's no question. And so that's a great example of a revelation story. And I would expect to hear a lot about how he gets involved in this. And then skipping relativity for a moment and go straight to redemption, because they're really inextricably tied together, which is, yes, I did this. Yes, I'm sorry. Yes, this helps you understand why. But more importantly, this is what I've done to make it right. This is what I've done to change my life. This is what I've done to make sure that I'm never going to be on the wrong side of the law again. And his journey to getting clean and rehab and speaking openly and helping others, and that's will be front and center to his, what I call his redemption story. To say, yeah, I screwed up, but I've been making up for it for years. And I don't care if you give me the so-called acceptance of responsibility or not. I've been walking the walk, and my actions tell you that I've accepted responsibility for my mistakes. You don't have to guess about that, and you don't have to guess about whether I'm going to be doing anything like this again, because I proved it with my actions, not just my words. Right? It's easy to get acceptance. You just say guilty, and you get acceptance. And then people get up there and say, oh, I'm really sorry, judge, because that's what you're supposed to say. And you get acceptance. Check the box. It's harder to actually show and prove and do with every day, every action you have. And I would submit that Hunter Biden has done that, and that's going to be an overwhelmingly powerful story here.
Well, and if I could interrupt, Doug, there is actually a specific provision kind of buried and a little convoluted within the guidelines that I think his attorneys really should exploit or bring to the court's attention. And that's 5H 1.4. And that is a provision for downward departures for physical condition or drug or alcohol abuse. Now, the face of 5H 1.4, when you read it, says that drug and alcohol abuse is ordinarily, that's the term, does a lot of work, ordinarily a ground for a downward departure. But it does also say that in certain cases, a downward departure may be appropriate to accomplish a specific treatment purpose. And one of the things that Hunter has been engaged in is rehabilitative efforts and going to therapy and things of that nature. That, as we well know, is not available in Bureau of Prisons. I mean, maybe facially, but not substantively. I mean, there's RDAP programs and all this other stuff, but frankly, Hunter's not going to get a long enough prison sentence to qualify for RDAP anyway. So,
well, by the way, this ties into the what I call the relativity arguments, which is let's compare this with that. This in relation to that. And there's many different strains. I won't go into them, but I think the most powerful one is, what if you send Hunter Biden, the son of a sitting president, or maybe a former president by the time, I don't know. If you send him inside the Bureau of Prisons, what does that punishment look like for him every minute of every hour of every day? Because even assuming there would be a drug program, like an AA meeting in the day room, or a little meeting with the counselor, guess what? He's not going to be in the day room.
Right.
He's going to be in solitary confinement, is my guess.
Yeah.
Because with all the political unrest and the Proud Boys and the angry and the white supremacists and the people who think Joe Biden's a pedophile and bleep blop bloop, like, I don't think there's any chance in hell, if I'm Hunter Biden, I can be in the general population. So I'm going to be locked away, which means no programming, very little human contact, and an exponentially more punitive, horrible sentence. And so I want to make sure the judge, that we're telling the story of prison at sentencing, to make sure the judge understands in no uncertain terms how unbelievably horrible and punitive that would be. And that in and of itself, I would argue, is reason to keep him out of custody. It's not because he deserves special treatment, because he's a special guy and son of the president. It's simply because he didn't ask to be the son of the president, but that's going to put his life in jeopardy.
Right.
Even in a little camp or a low facility, people say, oh, we'll go to a country club. Well, we talked about this a million times on our podcast too. There's no such thing anymore as the country club, if ever there was. These are dangerous, horrible. I just have a client who got out of the camp in Miami. It was gang infested. Someone just got stabbed and jumped there in camp or low. We had a client that got stabbed in a camp. We have there's a camp in I think it was the camp here in Tucson. They smuggled a gun. There was just an article where they brought a gun into the visitation room at the camp. Like, these are dangerous places, no matter what level of custody you get. They obviously get more dangerous as the higher you go, but don't think for a minute that a camp is going to be easy time for anyone these days.
And and also, I could hear some of the viewers and listeners yelling right now that well, he's going to have Secret Service protection. Well,
really?
Well, yeah, he has Secret Service protection now. I mean, he can defer it, or he could say he doesn't want it, but he does have it right now as the son, as child of a sitting president. They're entitled to it, and so that
how does that work?
Exactly that. So most likely he can't be in the general population because the Secret Service will not allow that, and they're not going to put an agent in general without a firearm, and nobody wants a firearm in a prison. So he's going to have to be in a special
unless it's Tucson, apparently.
Unless it's Tucson, right? or unless unless you have really good,
anything goes in Tucson.
Right. Right. So, but anyway,
Well, yeah, but we've had that same conversation when we talk about whether Trump can go into
right.
custody.
Yeah.
Same deal. It's
Yeah.
really, really tough.
It's going to be really tough for the BOP to put him anywhere. So even if he gets a sentence of imprisonment, and our friend Maureen Baird may be able to weigh in on this better than me. I'm sure she could.
Yeah.
But maybe the BOP just says, look, we can't house him. We're going to designate his home as the prison, which
Yeah.
they have the authority to do.
Yeah. And I
So,
think home confinement would be a perfectly
yes.
a perfectly legitimate consequence here. And I've argued the same for Trump, to be
Yeah.
honest.
Right.
I just said we should turn Mar-a-Lago into a prison and then forfeit it and turn it into the Museum of Democracy. But that's another story entirely.
Yeah.
Okay, well, so he has a lot to argue at sentencing, and I don't
Yes.
know if we usually do predictions. I don't know. Are you bold enough and brave enough to make a prediction about
Yes,
the
I
outcome of
am.
this case?
I am.
Yeah.
And so what I predict is he is going to get a year and a day. And yeah, that's going to be kind of steep, but it is rather consistent with the statistics that we looked at. Matter of fact, a little bit lower. And as we know, those that are sentenced to a year and a day pretty much get 15% off the top.
Yeah.
Yeah. So because
it's
of
a weird little glitch.
Yeah.
If you just get a year, you don't get any good time credit.
Correct.
So you serve
Correct.
a year, but if you get a year and a day, then you do 85%. So you get
Correct.
essentially 2 months, 54 days a year.
Yeah.
Does he is he precluded from First Step Act credits because of the gun conviction as well?
I don't think so. I don't
Okay.
think so because it didn't involve any violence.
Okay, so he might be able to earn
So he might be
extra
able to earn.
credit.
I could be wrong on that. I have to look because they have all these exceptions and everything now. But assuming he can earn first step credits, that will lower his time in incarceration even more. But I think
7 months probably.
Yeah, he'd probably end up doing like 6-7 months, something along those lines. But the reason why that's going to be a big win for him is it's going to help him with his tax case. Because I'm going to assume he's going to get a conviction for the tax case also. If he gets a sentence here of 13 months or greater, then that's going to give him 3 criminal history points. With 3 criminal history points, yeah, he's going to be now in criminal history category 2, going into the tax, going into his tax case. So that's going to make that sentence that much higher. So this may be a ground or an argument counsel may make to keep his sentence under 13 months. The year and a day would do that because then he would only get 1 criminal history point. And so therefore he'd still be in criminal history 1 going into his tax case.
Well, could he get 2 if he gets more than 6 months?
Maybe more than 6 months, excuse me. Yeah. So that he would get 2. No, that would still put him in 2. So he needs less than 6 months. That's correct. Sorry about that. Forgot about that. 6 months.
Yeah.
So he needs less than 6 months.
Okay.
But yeah. So no, okay. I'm gonna revise real time what I just said. He is gonna get a year and a day. He's gonna go into his tax case in criminal history category 2, and whatever sentence he gets there is going to be imposed consecutive to this sentence, since there's no relevant conduct between the 2. That's my bold prediction. He's going to
Ouch.
Yeah, he is.
Ouch.
Yeah.
Okay, so I don't know if I'm just being naive. I'm gonna just go with the home confinement. I just feel like the judge, I don't know this judge, and I've never been in front of her, and I don't know what her level of compassion and deviation from the guidelines is generally, but I just feel like if I'm a judge, I have a hard time sending someone to prison over this offense.
Yeah.
And I think that is the lead into the last topic that we're going to talk about, which is lawfare.
Yeah.
And I will start with the proposition before we dig into this word that you've told us the stats at the beginning of this.
Yeah.
At the beginning of this, I think it's not a stretch to say if you're not Hunter Biden, you're not getting prosecuted for this offense. I really
Yeah,
do.
I think that's right. Yeah.
There are so much politics involved in this. So that's what I think is giving me this idea of lawfare, because I see this online all the time and I get in fights with people on LinkedIn and everything else. But what I came to realize is I think there's a differing definition going on. And I think that a lot of folks on the right who are looking at all this stuff happening with the last president and
Mhm.
all his circle is this idea that they didn't do anything wrong,
Yeah.
because that's what the former guy perpetually says. I'm perfect. Everything was right. This was a perfect call. This was a perfect business deal. This was a perfect whatever. And or I never did anything. And
No.
so what their definition of lawfare is we have this criminal justice system that can be trained on completely innocent people and made to go to war against them and ruin their lives and take
Mm.
their freedom, even when they have committed no crime. And I generally I feel like there's always going to be exceptions to the rule because we're lawyers. There always
Mm.
are. And have we ever had people we think are really innocent that are being prosecuted for political reasons or something else? You're shaking your head. No, I say yes.
Yeah,
I
well,
do. I mean, but the question then becomes, um, what is innocence?
yeah,
Because the government can find if the government wants to prosecute you, Mark Allenbaugh,
yeah.
I guarantee you that you've done something
Oh
worth
yeah.
prosecuting. And
What was that?
I know
There's
I
that book
have.
out there, 53 felonies a day. We on
Yeah,
average we commit or something like that.
right.
Five felonies a day. Five felonies a day. We all commit on average. But yeah, I get your point, Doug. And I think at least with Hunter Biden, it certainly raises a question here, not just the G3 922 G3 count being rare, but all three counts being rare. And so the combination of rare upon rare upon rare, I mean, that certainly raises an eyebrow. And I
Yeah,
agree with you, but for him being Hunter Biden, the son of a sitting president, he never would have been prosecuted.
yeah. It
Or
doesn't mean he
or,
didn't.
or at the most, this would just been a civil tax matter.
Yeah,
Yeah,
yeah. And it doesn't mean he's innocent. The
yeah,
jury certainly didn't think so.
yeah,
But I do believe lawfare is real. But what I believe at the heart and soul of lawfare is that it is fundamentally about who the government targets,
yeah.
who they set their sights on.
Which
Because,
by the way, I don't know if you heard this, and I may have misheard this, but earlier today, one of the Hunter Biden jurors was being interviewed, and he said that when they initially voted, when they got the case to start deliberating, it was 6-6.
yeah, I heard that. I heard that.
So, this wasn't a slam dunk case by any stretch.
And there is such a thing as nullification, and
Yeah,
I think that may be the thing, because especially in these gun cases, I mean,
right.
I won more gun cases than I lost when I tried them in federal court. And there's two reasons for that. One is the ATF are the worst.
Mm,
They lie, they cheat, and they get, I sorry, it's true. Um, I literally, the first gun trial I did as a federal public defender, I won. It was a felon in possession. And the government, or the foreperson of the jury came out afterwards, gave me his business card, said, great job. And I thought that was nice. And then I watched him walk over to the case agent for the ATF
mm.
and looked him in the eye and said, every one of us knew he was guilty and wanted to convict him, but we couldn't because of the shitty investigation that you did.
Wow.
And I was like, okay.
Damn.
Um, but I saw that time and time again with the ATF.
Yeah.
They're reckless. They're cowboys. They cut corners. Not all of them, obviously, but boy, I really did see that almost every single case I ever had with the ATF had some issue in it. So that's an issue. Plus, people think people like their Second Amendment. People
Yeah.
like their guns. People don't like the government, the federal government, coming after you for ticky-tacky paperwork
Right.
violations.
Right.
And especially not in a state like Arizona. And God forbid you have this case up in Prescott, or when those people are out in the woods and they really value their cherish their Second Amendment. They don't want to see these cases. And so, you know, I guess Delaware maybe it's not the same or whatever, but what's the point? The point is, you know, the government doesn't prosecute these cases hardly ever. You've proven that.
Yeah.
And so what has Hunter Biden done to get on the government's radar? And we know. And you know, same with Trump. Like Trump has probably been doing things civilly or criminally that could get him in trouble for decades. But it wasn't until he came down that escalator and got on everyone's radar that he was
Right.
front and center and he had a target on his back.
Right.
And I'm not saying he should or he shouldn't. We're not going to talk about that here. But look at tax cases. Why does Wesley Snipes get a tax charge, and why does Martha Stewart end up getting into it? It's not because these are the worst of the worst. It's because the government knows if they
High-profile.
target a high-profile person,
Yep.
they can send a message to the rest of us little
Right.
people
Right.
that you
No
better
one's
not
above
step
the
up.
law.
No one's above the law.
Right.
I mean, I'm sorry, but where were all of these lawfare people banging the, you know, screaming from the rooftops when African Americans were getting disproportionately prosecuted and sent to prison for pot?
Right. 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 Exactly.
That's
Exactly.
lawfare because, you know, I'm pretty sure that I might have violated a law or two as a teenager in a cushy suburb, but there were no cops around. The government didn't have the light trained on me and my friends.
Right.
So we got by with everything, where the folks who lived in based on your skin color or your zip code got by with nothing. And that, in my opinion, is lawfare to the nth degree, but nobody seemed to have a problem with it until it was their people getting the light shined on them, the government light shined on them. It was always those people, and whatever's happening with those people, they probably had it coming. But now that it's our people, my people, all of a sudden this is the worst thing in the world. And I guess all I can say is, well, good, I'm glad it's on your radar now, because it's been that way since the beginning of the criminal justice system, when it was created to manage the newly freed slave population. And the 13th Amendment is passed where, you know, slavery becomes legal in the penal system, blah, blah, blah. Lawfare has been a thing since the beginning of the criminal justice system in America. And I'm really glad you white right-wing people are waking up to that fact. So now my question is, what are you going to do about it? That's all I can say about it. But this is lawfare. I really do.
Yeah,
it
is. But I mean, I think there is, you know, I think we may be coming to the end here, but I think there is something to say about, you know, prosecuting those that are really high profile, send a message to everybody else. And, you know, even though it may seem unfair to them, I mean, if they did commit a crime, you know, they committed a crime. And to say that Tom, Dick, and Harry aren't getting prosecuted too for it is no defense, as we well know. But where I think the opportunity to really send a good message is lost when one prosecutes somebody who's high profile, like a Martha Stewart or Wesley Snipes, or in this case, a Hunter Biden, is make the sentence symbolic and creative. Send a message through the sentence rather than just the old default sentence, lock them up for a few months, and everybody forgets about it. Big deal. Make something different. You know, because even federal judges can craft creative and meaningful sentences outside of just throwing them in prison, in an overcrowded prison system that's fallen apart with all those other problems, and not just sit at home and do nothing, but, you know, they require Hunter Biden to film PSAs, to, you know, write an editorial in some, you know, newspapers, something along those lines, give speeches about addiction and stuff, and you know, and to talk about it a bit more, you know, for free. He's not going to charge anybody or make any money off
community service, right?
Community service, exactly. I mean, that's where I really think Trump should get, by the way, a lot of that. Well, but that's. I mean, I hope if anything, I think he's going to get a year and a day, just because everybody defaults. When I say everybody, I mean federal judges, probation officers, prosecutors. Everybody defaults, unfortunately, to prison, and it's so unimaginative. There's so many other things than just prison.
Right.
And, you know, and
Right.
community service is
We
just
need
one.
to really be talking about alternatives
You're
to
right, exactly.
incarceration for
Because it's going to be
low-level,
more, it's going to
nonviolent
have more
people
of an impact.
especially.
Right. Well, here's my point. It's not to be lenient or to give Hunter Biden a break, but if you really want to send a message of deterrence and the fact that, you know, the rehabilitation means something and respect for law and all of that, if you want to send that message, putting people in the BOP doesn't do it,
Right.
especially when it's a high-profile case like this.
You will hear no disagreement from me on that point, and I think that is a perfect point to end. So thank you for doing this. This is cool. We don't do live stream that often,
No.
but I'm glad we did it today, and I hope that people pay attention because there's a lot
Yeah.
going on.
There is.
And if anybody wants to find Mark Allenbaugh, go to sentencingstats.com. If anyone wants to find me, I don't know, dougpassenlaw.com, setforsentencing.com. You know, and we're here, and we'll keep talking about this because it's important stuff. Have a good day, man.
You too. Thanks, Doug.